Morning, everybody. My name is Tracy Watson. I'm just going to introduce today's webinar. I'll explain the format, how you can interact and get answers to any specific questions that you might have. Today's is a 2-hour webinar providing an overview of the new rules that now need to be considered for exporting and importing services to Europe, which, as we know, is quite different to goods. There's quite a lot to take in, so we will include a short break halfway through to give you a chance to stretch your legs, top up your coffee cups. There is quite a few registered today, so I've muted the microphones to control sound interruptions. Not everybody has joined us yet that were registered, but we will crack on anyway. It is Friday, so some people might have changed their mind. If there's not too many, I could unmute mics later, but we'll leave them muted for the time being. You can post any questions throughout the session by clicking on the little Q&A icon at the top of your screen. You can choose to post your question to the host privately or just generally for everybody to see, and we'll respond accordingly. We will try to respond to as many questions as possible in the Q&A session, but if we do run out of time, don't worry, we will answer your questions. We'll get, or if we don't have an answer to hand, we will get the answers to the questions, and we'll add all the Q&As to the practical guide that will be published following the webinar. Finally, I just wanted to highlight that today's webinar is being provided through the 2 regional growth hubs. So before we dive headlong into the session, I'd like to invite Parvia Panu from the Northeast LEP Growth Hub to say a few words about the support they have available for Northeast businesses. Then shortly after that, that will be followed by Leslie Hawke, who will say a few words about the Tees Valley business support before we hand over to Ben. So if I can hand over to Parvia, please.
Thanks very much, Tracy. So I just thought I'd start with a quick overview of what the Growth Hub does. As you're probably all aware, the Northeast Local Enterprise Partnership is one of the driving forces for the economic plan for the Northeast. And the Growth Hub is really the delivery of that economic plan by helping businesses towards any of the support that they require to grow, thrive, resolve a lot of the challenges that they have. Part of that is our role as a connector, and briefly in a nutshell what we do is have conversations with businesses. The idea is really it's a diagnostic conversation, to have a chat with you, see how your business is doing, understand either the challenges that you're facing on one side of things, but on the other side of things also opportunities for growth or to expand your business, and see what support mechanisms are available in the Northeast that we can direct you towards in the lines of support, or funding is a big part of things that we do get a lot of questions with regards to. And the key thing is really to identify the right scheme for your business and direct you towards that. On that side of things, what I'd like to do is also share. We have 2 ways in which you can apply to speak to a connector who can help guide you towards the schemes we have. One way is via our website. We do have a form on the website. If you go towards the Growth Hub Connect, which you can see on the slide there, once you access that page, there is a form you can fill out to book an appointment with a connector. We also have a telephone number. I'll quickly just read that out. It's 0191 561 5468. That's 0191 561 5468. And you can call that number, and somebody will either direct or be able to speak to you directly, or be able to book an appointment with a connector for you to have a more deeper diagnostic of your business. To give you an overview, a diagnostic, I'd say, is about 20 minutes to an hour long, depending on the challenges your business would face. In many cases, a connector could have schemes to hand to be able to direct you towards, but on occasion we might need to step back to liaise with our team to see what scheme would work perfectly for you. So any questions, I'm happy to sort of address them while I'm around. And thank you very much, Tracy. I'll hand that back to you.
Thanks, Parvia. Now, if I can introduce Leslie from the Tees Valley Combined Authority Growth Hub.
Hi there, good morning everyone. I'm Leslie Hawke, I'm Business Advisor with Tees Valley Business. Ben, can you pop the next slide up please? Lovely, thank you. Tees Valley Business, we'd like to think ourselves as a bit of a one-stop shop for all the support, advice and guidance for the Tees Valley businesses to come to when they're developing any form of growth plan. So whether it be funding, finance, or signposting to other partners and stakeholders who can assist you, that's exactly what we're here to do and help you find. A couple of ways in which you can get in contact with us, which obviously is available on that screen at the moment, via our expression of interest form or via our email, both of which will end up coming to either myself or one of the other growth consultants, as Fia's just said, to undertake a diagnostic, just so that we know that we're pointing you in the direction of exactly what your business needs at that time. Next slide, please, Ben. And also, given the workshop that we're on today, we also have the amazing team of advisors that work within our EU transition team, who are delivering today, and who obviously were there to support you with any of your import or export or movement of good queries. And again, the information with which to contact them following this workshop is available on that screen there, and so you'll be able to see that on that recording. Next slide, please, Ben. And finally, just want to take the opportunity to thank you for giving me a few minutes just to explain who we are and what we do at Tees Valley Business, Tracy. And as I said, just hope you really enjoyed the workshop this morning. After spending 2 years at the Department of International Trade in the Tees Valley, I know that you're going to get real tangible information to support you as you go forward. Thanks so much.
Thanks a lot, Leslie and Pavi. So without further ado, can I introduce Ben Bradford, who will take you through today's presentation. Thanks, Ben.
Thank you very much, Tracy, and good morning, everyone. Welcome to our workshop today, focusing on the exporting and importing of services. So just quickly, what we'll run through today, I've split it there just into 3 sections for you. So we'll start off by looking at a bit of an introduction and digital services. Second section, we'll look at more and focus on in-person services, and we'll split that up with a bit of a Q&A session and an interval. And then when we come back, we'll finish the in-person services before moving on to the final section, which will look at the VAT implications of everything that we've discussed so far, whether that's B2B or B2C sales. And before we finish, we'll have another little Q&A session on just everything we've covered in that second part. So to help us explain what the theory means in practice, we're going to use Business Bob, our avatar, just to hopefully try and give you a bit of a practical idea and show the practical implications. Some of you may have already met Business Bob if you've been on one of the other workshops in this little series, but really for the purposes of this workshop, what we're saying here is that Bob's taken advantage from a local growth hub, and now he's going up a little bit in the world, and he's branching out, moving away from physical goods and moving into the services sector. And what his new business is we're looking at luxury sports and fitness service provider. He advertises and sells his services online, where he provides a mobile fitting service for a new luxury ski boot, which he sells online. He also runs a fun and fitness online membership health club that he uses to keep his customers up to date with latest products. And also he supplies and fits high-tech ski lifts and provides a maintenance and repair service to keep them in tip-top condition. So Bob sells these products and services to businesses and consumers all over the EU. He often has to travel to customer sites to install or repair these products. So hopefully that's kind of thing which we'll be using in our practical examples, and hopefully there'll be something which is relatable to you and your business and the service that you provide. So quickly, just before we delve right into it, just a bit of a snapshot of how important really the services sector is in the UK. The UK is primarily a services economy, with 80% of the UK economy coming from the services sector. And if you look at the EU specifically, then 42% of all trade with the EU is from the services sector. Now, if you only listen to the media, you may be excused for thinking that Brexit only affected exporting and importing of physical goods and didn't affect the services sector, but it does, and unfortunately it's probably been the services sector which has been left with the most doubt and unresolved issues since the 1st of January. So we understand that probably some of the biggest questions for yourselves and most people are, what is different and what do I now need to do? Well, now we've left the EU, our primary source outlining the new relationship between the UK and the EU is of course the Trade and Cooperation Agreement, the TCA. However, within the services sector, you will find that relevant regulations and guidance can be found in international treaties and international law, which is outside the scope of the TCA. And just to make it a bit more complex, within the TCA and the relevant regulations, you will see that it refers to various international groups. So it's not simply the UK and the EU. So what we're going to try and do today is we just try and help you understand what is relevant for your business and service, what is relevant for the countries where you provide your service or you obtain your service from, and how to locate the relevant information and how to check for relevant changes, because unfortunately it isn't all set in stone just yet. So to start with, what we'll do is just give a brief explanation of the different international groups and bodies, because these are important, and throughout the workshop and if you conduct your own research outside, you will see and hear reference to these other European groups outside of the EU, so such as EFTA, the EEA, and the Schengen group or the Schengen countries. So it won't be any help if I later refer to these groups and I haven't first given you some background information on who they are. So obviously with the EU, everyone knows of the 27 countries of the EU and the advantages they have within the EU, and obviously I don't need to go into any detail on that, and because that's what we've grown accustomed to over the last 47 years. The EFTA or EFTA, or the full name, the European Free Trade Area, what that is that's a small group of 4 countries. So it's Iceland, Norway, Liechtenstein, and Switzerland. None of them are members of the EU Customs Union. So what the UK has is the UK has separate trade agreements with these 4 countries. The EEA, now that's the term given to a group which combines the 27 countries of the EU and 3 out of the 4 countries that make up EFTA. And what that does is that creates a single market. The only country that isn't part of that is Switzerland. So like I said, it's all the whole of the EU and 3 out of the 4 countries in EFTA, obviously except Switzerland. So sometimes you might hear the term the EEA, or sometimes you might hear the expression the EEA and Switzerland. And finally, there's the Schengen area, and this was created to provide a single European travel area that is officially abolished all passport and other border controls between its member states, with the exception of Ireland. The rest of the EU is covered by the Schengen area. Many of the visa and work permit rules are similar between the Schengen countries. Obviously, as far as the UK is concerned, you must still check the entry requirements in each individual member state, as they can differ slightly. And it's important to understand how the Schengen rules affect our access to Europe when we're travelling to provide a service, and we'll cover that later in the workshop. So like I said, it's just important that we cover those terms very quickly and hopefully get you thinking what countries are relevant to you and how do those countries fit in. So if you're talking Switzerland, hopefully you understand that an EFTA country If it's talking about EEA, you'd have to make sure that it's EEA and Switzerland. Similar if it's maybe Iceland, for example, Germany, France, whoever. Hopefully starting to think about the countries that are relevant to you and how they fit in. And what you can do there, that link at the bottom of the screen, that'll just take you to the government webpage where you can find some further links and information on the individual country requirements. Because like I said, they will differ per country, and we'll get to that shortly. Now, the section of the TCA relating to the supply services is based mainly on the WTO's General Agreement on Trade and Services, or GATS as it's better known. GATS makes up, or 164 countries have signed up to GATS. So it is the largest agreement for the supply services, and it goes far beyond the UK and the EU. So we're going way beyond the TCA here. To put it simply, because I don't want to go into too much detail on it, but to put it simply, and really to try and dumb it down a little bit, I suppose, the general objections of GATT is to provide equal opportunity to compete and allows for access into other markets. So for example, if Business Bob had a counterpart in the USA and both wanted to set up an identical business in France, the French authorities could not set different standards for the American or the UK business, and that is known as the most favoured nation treatment. So regulations can be set, and countries can set a bar, and different countries might have different bars depending on your qualifications or what you're wanting to do in that country, but those bars cannot be set at a different height just because you're a UK business or an American business, for example. So I'm looking and just thinking, how does this affect the UK and their new relationship with the EU? Well, for instance, member states are permitted now to apply certain restrictions specific to their own country. So these could be restrictions on professional qualifications, time limits on visiting in person, visa requirements, e.g. whether that's job offers in advance, or in some cases, even the need to have passed an economic needs test. But at the same time, the EU can't demand that UK service providers set up a local subsidiary before starting to provide the service in their country. And this keeps the market open and makes access easier for cross-border training. And like I said, the most favoured nation, well, that provision ensures that service providers from one country are treated as equally favourable as those from another, more favoured nation. And all in all, these provisions allow for the UK and the EU continued access to one another's market for the supply of services. But this new relationship, though it's been set up in the TCA, it is still evolving and developing, and it's still fleshing out. So first, like I said, we'll look at digital services and consider the changes that relate to businesses who provide the online services from the UK to countries in the EU or vice versa. And this is a list of the type of businesses that might be affected. And by no means is it an exhaustive list. It's just an indication really of how widespread the services industry reaches. So firstly, we need to look at where we are with personal data and how has this been affected by the EU exit. Well, personal data is, quick definition, any information that can be used to identify a living person, including names, delivery details, IP addresses, or HR data such as payroll details. Most organizations use personal data in their daily operations. And as you'll be aware, the EU's General Data Protection Regulations, so GDPR, require that personal electronic data must be handled according to the GDPR rules. Well, since the 1st of January, the EU's GDPR rules do not apply to the UK anymore. But essentially what the UK has done, the UK has picked up the old EU law and dropped it into UK law, basically adopting the GDPR rules from the EU and the ones that we are most familiar with. Now, despite this, as we're now seen as a third country in the eyes of the EU, what we need is they need to undergo their procedure to ensure that the UK's data regulations are up to the relevant standards. And this process is known as data adequacy. When the EU Commission provides a third country with a data adequacy decision, information can then pass freely between the third country and the EU. Without a data adequacy decision, then it can be more difficult, and unfortunately, the UK is no different now to any other third country. As we currently stand, a bridging mechanism was introduced and agreed upon, and that lasts for a maximum of 6 months from starting from the 1st of January. And what that's been put in place is just to allow data to continue to flow freely until this adequacy decision has been agreed. The EU Commission have confirmed that a draft decision which states the UK data regulations are to the required level, but unfortunately the draft decision requires ratification, and currently there's no suggestion as to when the ratification will take place. So to recap, the UK need a data adequacy decision from the EU to move data freely. We've informally been provided with that decision, but is yet to be rubber stamped, and that is what we are now waiting for. When will we get the rubber stamp? Unfortunately, we just don't know. What I would suggest is keeping an eye on the Information Commissioner's Office, the ICO's website, which will provide you with any updates on the data adequacy decision. And also you might find it useful just to read the ICO's information on standard contractual clauses, SCCs, which they recommend implementing if no data adequacy decision has been made by the end of June. What they do is they provide a useful interactive tool on their website which creates the most relevant SCCs for your business, and there's a link there on the bottom of the slide. And they suggest that for majority of businesses, if you incorporate these SCCs, then regardless of us not having the adequacy decision, that will allow data to continue to flow. So as kind of a safety net, that's what they recommend looking at and implementing. And just a quick note, personal data can continue to flow freely from the UK to the EU. The adequacy decision only concerns the EU to the UK flow of data. So now if we just look at intellectual property protection, and within the umbrella term intellectual property, there are many different rights. The UK leaving the EU will have had varying levels of effect on your product depending on the right which you rely upon. I will quickly just run through the different IP rights and how the changes will affect you and your product. So firstly, EU Trademarks and Designs. Well, on the 1st of January, the IPO created a comparable UK equivalent for every trademark and design registered in the EU. The UK version has the same legal standing as the original. You won't receive a UK registration certificate, but you will be able to take a screenshot of the online details from the gov.uk website. Any unregistered applications will not automatically transfer, so organisations have 9 months from the 1st of January to apply via the UK to retain the EU filing date advantage. But if you're doing that process, then UK fees will apply. Now, if we look at unregistered community designs, so UCD, if you relied on a UCD which existed before the 1st of January, then you will continue to be protected in the UK for the remainder of the 3-year term. However, since the 1st of January, the UK now has its own UCD protection in UK law, and what that's called the Supplementary Unregistered Design, so SUD. It'll work like the UCD, but obviously applies to the UK only. UK SUD will be established by first disclosure in the UK or a qualifying country. Now, to note, the EU is not a qualifying country, so first disclosure in the EU is not a qualifying design. So you just need to consider the location of your first disclosure just to ensure that you have adequate protection in your most important market. And quickly, just quickly fly through the next couple of rights, IP rights. If we look at patents, as the European Patent Office is not an EU agency, leaving the EU does not affect existing EU patents, and existing EU patents covering the UK are unaffected. If we look at supplementary protection certificates, so SPCs, again, just quick note, as these are granted nationally rather than EU-wide, so any existing SPC will not be affected and the application process remains unchanged. Parallel trade, just for you to think about, you might need to get the right holder's consent if you want to export back into the EEA. If we look at copyright, most UK copyright works will still be protected in the UK and the EU because of the UK's participation in the international treaties on copyright, and that works the same with EU copyright as well. However, certain cross-border copyright arrangements between EU member states no longer apply to the UK, and the effect on UK copyright works may depend on domestic legislation within each EU member state, as well as your private contractual relationships. And finally, geographical rights. UK has introduced new UK GI schemes, which should ensure existing relationships between trademarks and GIs are maintained, and more information is available from DEFRA, the government department, who have published guidance. So we'll move away from that and we'll have a quick look at .eu domain names, because if you have one or if you used to hold one, you'll probably already be aware now that it no longer works and it's no longer available. So like I said, just touching on this subject lightly. You should note that as we are now a third country, UK businesses no longer permitted or own a .eu domain name unless you meet certain criteria, which involves nationality and residency or location of the business. And this includes top-level domain names from EU member states, such as the FR for France or ES for Spain and DE for Germany. If you own a .eu domain and you're unsure if you meet the criteria to retain it, you should get more information by following the link on the bottom of the screen there. So now if we bring in Business Bob, here's a bit of a practical example. So there's a couple of points for him to consider with his fun and fitness online membership health club. The domain name used to be www.businessbob.eu, which is obviously a red flag, and he'd only be allowed to use if his organization or business was established in the EEA, or he was a resident in the EEA, or an EEA citizen. Now, unfortunately for Bob, he doesn't meet these this criteria, so he would have to change his domain name. The .eu domain name will be suspended until the 30th of June this year and will be withdrawn on the 1st of July. So Bob is now going to have to discuss this with his local domain name registrar to try and transfer his internet presence to another top-level domain, so such as .com or .co.uk. And you'd have to look at implementing a holding page to redirect his customers to the new domain. As Business Bob is concerned, Business Bob is concerned about personal data he obtains from customers all over the EU. So using the ICO's website, what Business Bob can do is he can incorporate the standard contractual clauses, like I said, just as a precaution, as a bit of a safety net in case the adequacy decision is not ratified before the end of June. But if it is, if we get that adequacy decision in place, then like we said, the data can continue to flow freely. So if we just have a look there now, switch it and have a look at supplying a service in person. So what we're going to try and think about here and cover is business travel and entry requirements, recognition of professional qualifications, driving to work in the EU, before looking at maybe some customs special procedure, most notably inward processing relief, and taking equipment abroad and how that has changed and what you now need to do or put into place. So now if you travel to the EU for business, you do need to prepare, and I suppose you can probably split it up into two lists in your head, both with that you can check off, checking what you need to do before traveling, and then check what you need to do before actually working in that EU country. So you need to check whether you need a visa or work permit or other documentation and apply if necessary. You need to ensure you have appropriate healthcare insurance, check your passport expiry date and renew if necessary. And if driving, ensure you have all the required driving documents. And before working, you might want to consider just a few basic points here. Things like check if you still need to pay UK tax while working abroad, check whether you need indemnity insurance for your employees, ensure your professional qualifications are recognised if you provide professional services, and check that your indemnity insurance covers you working in the EU. There's a couple of points there, just try and get you thinking along the right lines. Obviously, depending on the type of work you're doing, that list might be longer for you, and that's fine, but just trying to get you thinking along the right lines. And a brief little note there at the bottom about the common travel area. So really here, when we're talking about the EU or the EEA, we're excluding Ireland, Republic of Ireland, Southern Ireland, because of the common travel area and how British and Irish citizens can work and live in the UK or Ireland without needing additional permission. So we're looking at the rest of the EU or the EEA in these circumstances. So as mentioned earlier, we covered the Schengen Agreement and Schengen countries, and we explained how they cover all of the EU and EFTA countries apart from Ireland. And if you're traveling into the EU, you'll need to understand the Schengen rules. The first thing to check is the passport requirements. So your passport must not be older than 10 years and must be valid for 3 months beyond the date you will be leaving the area. And it's worth noting here that some older passports might have a lifespan of more than 10 years if they were renewed early, but they will now expire 10 years from when they were issued, not at the extended expiry date. So you should check when the actual expiry date will be and ensure it does not run out too early. If you provide services in the EU or EFTA regions, you'll need to make changes. So each member state have different rules, and their rules will affect you if you are a UK-based supplier providing services to the EU or EFTA. If you are an owner, manager, or a director of a company in the EU or EFTA, if you are traveling to that area for business, or if you need professional qualifications to provide a service to an EU or EFTA business. And it's worth noting that as a general rule, you can travel to the EU for up to 90 days in any 180-day period for certain purposes, i.e. conferences or business meetings, without obtaining a visa in advance. If you provide work while in the EU or conduct more than simple business meeting, you may need a visa. And I suppose the exact point when a visa is required or which visa you need to obtain would depend on the specific country. So depending on the country, the bar might be set at a different height, and the name or the specific type of visa you require, or the details you need to provide, or the hoops you need to jump through may slightly differ depending on the country. So it's important to prepare and make sure that you understand the requirements for the country you wish to provide that service in. And that's what we're getting at here, the type of things that you need to consider before traveling, and how that's changed and the relationship's changed since the 1st of January. So like I said, if you're traveling for less than 90 days in a rolling 180-day period for tourism or business meeting, you don't need a visa. And some countries will allow some extra activities without a visa. If you travel for more than 90 days in a 180-day period, then a visa or work permit will be needed. So if you're doing any of the following, then you may need a visa. Just give you some idea of when one might be needed. So if you're transferring to a subsidiary or branch of the same company in a different country, so like an intra-corporate transfer, if you're carrying out a contract to supply a service to a client in another country in which your employer has no presence, so as a contractual service supplier, maybe if you're carrying out services in another country as a self-employed person or as an independent professional, or maybe if you're moving temporarily to invest for yourself or on behalf of a company. And like I said, even though the Schengen countries' rules are based on the same agreement, it doesn't mean they're all identical. So it is important to check the rules on the country's website to see if you need a work permit or a visa. And if you don't check, then you may face delays or administrative barriers. Again, link on screen here, same one I think as we showed earlier. I'll just give you some useful information that is specific to the different countries, and also give you the relevant body or embassy to go to start off the process of what you need to do to obtain a visa. And like I said, sooner you start that and sooner you plan ahead, the better, because not always going to be a simple procedure. You may be required to travel to an embassy, and different documents will be required depending on the work and what you wish to conduct. So soon you start that process, and soon you understand what type of visa you'll need or whether it will be needed, then better it will be for you and your business. In addition, it's worth bearing in mind at the moment that due to current COVID restrictions, you may also need to check how the COVID entry restrictions will affect your plans and affect the visa application process. So now if we move away from the visa application process and we get to the point where we're thinking about what you'd actually need to do to drive in the EU, because again, since 1st of January, there are some new steps you'll need to take just to prepare in advance of your journey. So you would need a green card, an international driving permit or a UK photo card driving license, a certificate of motor insurance, your vehicle's logbook, so the V5 logbook, and a GB sticker, unless you have a GB license plate. So just touch on a couple of those, and we'll start off with the green card. Now, green card is a document, also known as an international motor insurance card, that proves you are insured to legally drive in the country you are visiting. You should be able to get one from your insurer free of charge, and make sure you allow plenty of time for this, as they usually take, I think, a fortnight is a general rule, take a fortnight to process, and you will need to carry your green card in most European countries. If we look at the international driving permit, you wouldn't need an IDP to drive in the EU country as long as you have a UK photo card driving license. Type of circumstances where you may need one is if you have a paper driving license or a license issued in Gibraltar, Guernsey, Jersey, or the Isle of Man, then you should check with the embassy of the country you are driving to. And also, if you're looking to rent a car in the EU, then the AA does recommend that you take an IDP, just in case. Because worst case scenario would be you got over there, tried to rent the car, and you found out that for whatever reasons you required one and you didn't have it on you. You can apply for an IDP if you're over 18 and have a full driving license. A standard IDP will cost, I think it's £5.50, and you can get one from a post office or via post. So shouldn't be too much of a onus on you or financial burden on you to obtain that. And like I said, in some circumstances it might not be needed, but in some it will be worth taking just to make sure you're covered. And like I said, a GB sticker is needed unless you have a GB number plate. And there we go, just an example of the green card. Like I said, you'll need one for each vehicle you get from your insurance company. You'd need a separate one if you're pulling a trailer. You'll need to show it if you're in an accident, and you may need to show it as you cross a border into another member state. And just to make the point, don't want it to sound daft or anything, but it is called the green card. Picture there is on green, but it doesn't have to be on green paper. Okay, it's just the name it's got. And we'll continue looking at providing a service in person. So what we're looking at now is we're looking at professional qualifications and working in the EU. So the TCA provides new arrangements for the recognition of UK professional qualifications in the EU and vice versa. Through the UK EU Partnership Council for Professional Qualifications, it enables the EU and the UK to agree mutual recognition of professional qualifications, whilst not affecting either side's right to set a fair standard that they must meet or must be met by professionals to practice. Now, this new process should eventually develop into a UK EU-wide arrangement for the benefit of all and all different sectors and businesses. So over time, I think the plan is hopefully that you'll see this will flesh out, but currently it's best way to describe it is it's bare bones, and over time you'll see it grow. So in the meantime, each member state has its own rules, so UK qualified professionals wishing to supply services in the EU should seek recognition of their qualifications by the appropriate regulator in that country where they intend to work. And even whether that work is temporary or occasional, you should look at the rules for that specific country. If you already work in the EU or an EFTA member state, and your qualification has already been recognised by the relevant regulator in that country, you should just take steps just to ensure you fully understand the terms of your recognition decision, just by checking in with that regulator, asking them the question, and just getting some clear answers on if there's anything extra you need to do, or whether you're allowed to continue as were, or whether there's any new restrictions on you. And just to note, there are some specific guidelines and information is available for the legal profession and auditing services, and you get some more details and information on those two sectors from the gov.uk website. So it's important to realise kind of what does this mean for you, what does your business need to do. Well, best place to start is maybe just to check the European Commission's regulated professions database, just to find out if your profession is regulated where you intend to work. Contact the single point of contact for that country to find out how to get your professional qualifications recognised, and obviously get your qualifications recognised by the appropriate authority or regulator in each country where you intend to work. And you may find that in some cases the qualifications may need to be recognised by a regional authority rather than a national authority. Thinking of an example off the top of my head, I believe in some circumstances maybe Germany works in that kind of way, where you might have a regional authority rather than the national authority. So just hope we get started. Here's a couple of links which hopefully might find useful, and like I said, hopefully how you just understand the regulations and requirements in the country which is specific to you, whether you need your professional qualification, whether it's regulated or not, and if so, how you go about making sure that you can work in that country. And like I said, the hope is that this will continue to develop and become a little bit easier as time goes on. Now, if we flip this on its head and look at employing EU professionals rather than looking at your professional qualifications in the EU. So if you're employing an EU or EFTA professional in the UK, then again, you'd need to ensure that their professional qualifications are recognised by the UK. And to do this, you should check the UK list of regulated professions. We've got a link for that there. And use the address provided just to contact the relevant UK regulator for further information if needed. And it's worth noting here a point which is slightly beyond this webinar, but if you're employing a EU citizen, they will need to check their visa obligations. Now, the specific visa they require will depend on the sector they work in and their qualifications. So depending on whether you're talking degree level, whether you're in a specific sector, whether that's working in scientific sector, whether you're in the creative sector, there'll be different visas available with different requirements. And also as an employer, you'll need to ensure that you understand your responsibilities and obligations if you are looking to hire anyone who holds or requires a visa. So in some circumstances, just as quick examples, the individual may already require a job offer from you to be able to obtain the visa, or you may require to become a sponsored on the visa program, which is requires some paperwork on your side, and also there are some costs involved in that, which again you can look on the gov.uk website and see how you go about obtaining that sponsorship, so you're then able to employ someone who requires or who has already obtained that visa. It is also important that we just touch on customs special procedures. Now, these allow you to store or temporarily use, process or repair goods and get partial or full relief from import duty and VAT. Now, most of these apply to the import or export of goods. And I know here that obviously we're focusing on services today, but there are a couple which I just want to highlight to you, and hopefully you may be able to take advantage of. So just going to go into a little bit more detail about ATA carnets, the duplicate list and inward processing. And just to help put this into a bit of practical context, I will be using Business Bob and a couple of examples from the work he conducts, and the links there at the bottom will provide you with some more information on the things that we are about to discuss. So firstly, the first Business Bob dilemma is taking equipment with you. So every year in the summer, Bob heads off to the Alps to do his annual maintenance checks on the 4 ski lifts he sold to ski resorts out there. And previously, he's just checked his bags in at the airport, hopped on the plane and headed off. But this year, unfortunately, it's going to be different. And Bob, and in order for Bob to take his equipment with him, he is going to need to rely upon a customs special procedure. And in this instance, Bob is going to have a look at obtaining an ATA carnet. So what is a ATA carnet and what does it do? Well, if we look at Business Bob, for example, here, he will need to take the equipment with him to complete the service. The equipment would need to be exported, and then when he returns, he would need to re-import them back into the UK. And save him from paying these customs duties and taxes, he will apply for an ATA carnet, which is a bit like a passport for goods. So an ATA carnet is an international customs document which allows the temporary importation of commercial samples, professional equipment, or goods going to either a trade fair or an exhibition to countries which are part of the ATA carnet system. And the ATA carnet system goes beyond the EU, but all the EU and EFTA countries are part of that system. And obviously, with today's focus being on the EU, we will focus on that, but it's worth checking if you may have the same issue further afield. Check whether an ATA carnet can be applicable and can be used in that country. Now, without an ATA carnet, you would need to complete each country's custom procedures for the temporary admission of goods. Obviously, that will involve more paperwork, additional paperwork, and maybe the financial expense of paying duties and VAT. Like I said, what an ATA carnet is it just acts as a passport for the goods, and it simplifies the custom formalities by allowing a single document to be used for clearing the goods through customs. It's valid for 1 year and allows for the movements of goods shown on the carnet as many times as required during that 12-month period to any of the destinations applied for. You can apply for an ATA carnet online at the International Chamber of Commerce or the London Chamber of Commerce. And the cost is currently, I think, quoted at £300 plus VAT, and that's for non-members. I think if you are a member, that there is maybe a discount there available for you. Once it's issued, they can either be posted out or collected from the issuing office, and then you can travel only to the countries listed on the green front cover. All items declared must be returned within the validity of the carnet, and all goods must be returned. If any goods are not returned, they will be subject to duty and may incur fines. And once you're done with the carnet, then it must be returned to issuing body after the expiry date, or like I said, after the visits have been completed and you have no further need for it. So we'll just use a bit of example here. So like I said, you'll need to apply for an ATA carnet either online or via post, £300 plus VAT for that, and you may need to pay a security deposit. On leaving the UK, you'd need to present the carnet and goods to customs official at the airport, and then the official will check. They'll check and certify the green front cover. They'll check, stamp and detach the yellow export voucher. They'll complete and stamp the yellow export counterfoil and then return the carnet to you. Now, make sure you contact the airport prior to departure to check when a customs official will be available. Depending on the airport, they might not always be there for you when you need them. And the last thing you want is to turn up to the airport 2-3 hours before your flight, just to find out that no one is available. So what happens then is the carnet's been stamped and approved, so we can now fly to our destination country here of Switzerland. And then when you arrive in Switzerland, what you need to do is present the carnet again for approval. So you and the Swiss Customs Office will need to complete the white importation voucher, and again they'll be stamped for approval, and that'll be on the voucher and the counter foil, which then shows that your carnet has been approved. And just point there'll be no further clearance required to travel to any other EU member states once that there has been approved. Business Bob will conduct the work he needs to on the ski lifts in Switzerland, and once he's done, obviously then he'll need to look at re-exporting the tools and the equipment. Again, both Business Bob and the Swiss Customs will need to complete the white re-exportation voucher. Again, it'll be completed and it'll be stamped along with the white counterfoil sheet, which show that that has been approved yet again. So what you can do now is you've got your approval, that's been stamped, so your goods are ready to re-export. And then when re-importing into the UK, if the goods are in your baggage, then you need to go through the red channel at customs. The yellow voucher for re-importation will need to be completed, as will again the counterfoil, which will be stamped. You finished with your ATA carnet, it's done its job. So what you need to do is return the carnet, like I said, to the issuing body either after the expiry date or after all the visits have been completed. So there it is, just a bit of a visual kind of idea and flowchart of how that ATA carnet works in practice. There is, and it's worth noting, an alternative to the ATA carnet, and that's called the duplicate list. There's no fee for this, and again, you wouldn't have to pay any duty or VAT, but it is a more complex and maybe onerous process on you. You can, like I said, use a duplicate list method for goods that are in your baggage, same way that you can ATA carnet, and you could use it for goods such as professional effects or tools or film equipment, musical instruments, works of art or other goods for an expedition or display or demonstration, trade samples, or even trophies from a recognised UK sporting association. Before you export the goods, you would have to prepare a list on company stationery, and that list would have to include a description of the goods, how many of each item there are, the serial numbers, if the goods have them, and the value of the goods. So you can imagine if you're taking over a fair chunk of tools or equipment, that list can certainly start getting long. And at customs, you need to provide 2 copies of the list, a completed returned goods relief form, and you must contact HMRC Import and Export Helpline in advance just to make the arrangement for clearing through customs. You'd need to arrange for customs official to be present to clear the goods, the same as with the ATA carnet. And worth noting that the country you are importing the goods into may require a financial security bond in case any of the goods do not leave the country again. The goods must return within 3 years, so you've got longer than you have with the ATA carnet, and all the goods or items on the list must be returned, or again, you'd run the risk of paying duty, VAT, or a fine. In the import, you can do a manual declaration, but it's a bit of an administrative burden, and if you get it wrong, it will cause a hold up at your port or airport and may stop you from being able to take your goods or tools with you. So, like I said, it's an alternative to an ATA carnet, but it probably puts more of an onus and burden on yourself. So it might be worth first having a look at the ATA carnet, having a look at the International Chamber of Commerce or the London Chamber of Commerce, seeing what it entails and seeing if that is something which is relevant for you and your business. Second dilemma for Business Bob is repairing products. So a customer has complained that his ski boot cuff riveting system, for example, is faulty. So he'd need to get the boots back to the UK for repair. Obviously, the main concern here, or the main worry for Business Bob, is that he would now have to arrange for the re-export from the EU, the re-import into the UK, and then organise for the goods to be sent back to the customer. And obviously, with that, you've got duty and VAT obligations, and he's worried that would all start adding up. So in this scenario, Business Bob may want to look at inward processing relief. Now, this allows you to import goods, process or repair the goods, and then export the goods without the need to pay customs duties and import VAT. So would be a good solution to Business Bob's dilemma. The steps you need to take will depend on the type of authorization you require. And thinking of Business Bob's example here, there may be a couple which he wants to look at and focus on, and that would be full authorization or authorization by declaration. So if we look at full authorization first, well, that's suitable if you regularly use inward processing. So if this dilemma occurs regularly, it allows you to use simplified declarations to import or export the goods. Because of the application process for a full authorization, it generally takes a month, or at least a month, to start processing that. Now, obviously, in Business Bob's case, he's not going to get 1 month's notice before his customer wishes to return the goods. So if he believed he needed full authorization, then maybe he should start the procedure sooner rather than later, because, like I said, there's no point waiting till a customer actually wants to return the goods for repair. So that's something you might want to consider. As an alternative to that, you've got authorization by declaration. Now, this can be used up to 3 times in a rolling year for goods valued up to £500,000 for each import. And there are limits on the goods which can be authorized through declaration. So you might want to have a look at that and see whether that applies to you. Now, in Business Bob's scenario here, it may be easier for him to rely upon declaration via authorization by declaration process, but he'd have to start thinking about how many customers does he have in the EU, and from that, roughly what amount of goods is he expecting to import, and what is the likelihood that some of them may have to be returned for repair. And when you're thinking along those lines, do you think that you are going to have to rely on authorization, or you're going to have to rely on inward processing relief more than 3 times a year? Because if so, then obviously authorization by declaration may not be the best solution for you, and you may want to start looking at how you become authorized for a full declaration. Now, I'd suggest speaking to your customs intermediary if you wish to rely upon inward processing well in advance of actually importing the goods. So both you and your customs intermediary can be aware of your intentions, and both parties can understand what information needs to provide or what is required from them. Alternatively, if you have any queries, you can use the contact details from the beginning of the workshop, and we'll repeat them at the end, just to contact us, and I'm sure we'll be happy to look a bit deeper into your specific query. And that message is the same regardless of which customs special procedure you are relying upon. And a link on the screen there give you a bit more information as well about what inward processing relief is and what it would require from you, so you can balance out really, are the requirements the onus on you, is it worth the advantages, or can you take advantage of them for your products. So if we now look at how to establish a business in the EU, so if we look at what's changed, well, like we said, the UK no longer has freedom to establish businesses in EU or EFTA countries, and we're treated as third country, so your business will be treated as a third country business. Well, what you do need to know, well, as a UK business or a UK citizen, you may face restrictions on owning, managing, or directing a business. Depending on the sector or the country you are operating in, there could be different requirements on nationality or residency of senior managers or directors, as well as limits on the amount of equity that they can hold. Businesses registered in the EU may need to comply with extra legal requirements for registering. Branches or representative offices may also need to comply with new rules. So whether you're looking to establish a new business in the EU or open a branch, or you're involved in a cross-border merger, I would suggest seeking legal advice, or maybe you can seek some guidance through people like the International Trade Advisors, the ITAs, who I know as well, can provide you with some really good support and advice on how you can expand your business and how you can set up and develop in the EU since the 1st of January. So now if we just move on to our final section, we're looking at VAT and how it affects the direct the different sections and topics which we've touched on so far, and highlight the differences between B2B and B2C sales. So as you can see, we'll be touching on a few different points. And determining who is liable to pay VAT on the supplier's service depends on a number of different things. And a quick point, as the UK is no longer part of the EU VAT regime, the reverse charge scheme is no longer available to British businesses. There may be one or two exceptions to this, but any queries in this regard should be referred to an international VAT consultant. So the first point we'll be looking at is how to determine who is liable for paying the VAT and how this differs depending on B2B or B2C. So no matter whether you are exporting or importing a service, VAT will be payable, and where the VAT is payable will depend on whether the customer is a business or a consumer. So like I said, we're talking B2C or B2B. So firstly, B2C, if the customer is a consumer, the VAT is chargeable at the place of supply, and the service is supplied where the supplier belongs, irrespective of the location of the customer. If the customer is a business, so if we're doing B2B, the VAT is generally charged in and at the rate in the customer's country. So the service is supplied where the customer belongs. Now this is the general rule. Okay, and we'll go on to some of the exceptions in a bit. There's a general rule there. You need to look at whether it's B2B, B2C, and the difference and how that changes the actual place of supply. So as an example, if you supply a service to a business in the EU, the service falls within the scope of the VAT scheme in the country where that business is based, and VAT will therefore be charged in and at the rate of that customer's country and payable to that country's VAT authority. So you need to just try and determine and think about who is the customer. Are they business? Are they consumer? You need to then have a look at whether special rules apply or whether the general rules apply, and whether or not the VAT is recoverable. Unfortunately, the specifics on that part are probably well, they're out of the scope of this workshop, and your VAT accountant would be the person to advise you on that. Quick note on Northern Ireland and the Northern Ireland Protocol, that only applies to goods. So it doesn't impact on the rules relating to VAT and on the supply of services. Non-UK service suppliers who are not established in the UK may be liable to register for UK VAT. So like I said, it depends on whether it's B2B, B2C, and where the supply takes place. And we'll quickly just look at the place of belonging, because that's the place where the supplier or the customer belongs, and that will determine where the VAT is due. So for businesses, you belong in the UK if you have a business establishment in the UK and no fixed establishment elsewhere associated with the supply. It may be a business establishment outside the UK and a fixed establishment in the UK, but it's the fixed establishment in the UK that's mostly directed or connected with this supply, or maybe no business or fixed establishment anywhere, but your usual place of residence is the UK. A private individual who receives a service, so a consumer, they're treated as belonging in the country where they have their usual place of residence. If a person has only one usual place of residence at any one time, and they're usually considered to be resident in the place where they've set up home with their family and where they work full time. Private individuals are not residents if they're here as tourists, or if they're in the EU member state as a tourist. So I said that a couple of slides ago, that was the general rule. And like I said, there are some special rules or exceptions to the general rule. Quickly run through some of them here. So there are exceptions if we're talking land related, the hire of means of transport, services including admission linked to physical performance, passenger and freight transport, intermediary services, B2C supplies of certain services to customers outside the UK, use and enjoyment rule, and B2C supplies of digital services. So you should consider the nature of the service against each of these specific rules first, and only if none apply to you or your service, that is when it will fall under the general rule. Now, unfortunately, we can't go into detail on each of these rules, but what we'll do is I'll focus firstly on the use and enjoyment rule. So this rule is intended to make sure taxation takes place where services are consumed, and the services covered by these rules are the letting on hire of goods, electronically supplied services, so only B2B, telecommunication services, again B2B, repairs to goods under an insurance claim, B2B, and radio and television broadcasting services. So from a UK perspective, the use and enjoyment rules apply in either of the following situations. So it might be that if the place of supply is inside the UK, but the services are effectively used and enjoyed outside the UK, then that would escape the UK VAT. Or alternatively, if the place of supply is outside the UK, but the services are effectively used and enjoyed inside the UK, then they may fall in the UK VAT rules. Now, in these circumstances, the place of supply, like I said, is where the service is used and enjoyed. And whether this is inside the UK, then the service is subject to UK VAT, or vice versa. If it's outside the UK, then it will be the VAT in that member state. So the service is regarded as being used and enjoyed where the customer consumes the service. So this could be where the customer is when they make the telephone call, or use goods under hire, or watch the live broadcast, or maybe if they're a business who purchases downloaded information over the internet for use at a specific site in another territory, or use repaired goods in the UK. So if in some circumstances that may be relevant to you, a service may be partially used in the UK and partially used outside, and the VAT liability needs to be apportioned between the two territories. So UK VAT will only be due on a portion of service consumed here, and the EU VAT would be due on the portion of the services consumed abroad. So if we just use a quick business Bob example, where he rents out luxury ski boots to a UK customer for use on holiday in the French Alps. The place of supply is outside the UK if the customer is able to demonstrate that ski boots are used and enjoyed in the Alps, and this is because the goods are used and enjoyed outside the UK, and the place of supply would otherwise have been inside the UK. Or if we have a look at if UK business purchases a fitness video for skiers from Business Bob's online health club for use in its UK headquarters and maybe its German branch. Although the supply is received in the UK, is outside the scope of UK VAT to the extent that it was used in Germany. So you've got UK VAT is due on the portion in the UK headquarters, and German VAT on the portion in the German headquarters. So that's maybe a good example of how that is split. So if we look here, and there's some just little examples to ponder and look at, and if you see in each of the 6 different scenarios on screen, really there we're mainly talking about trying to get you think about, well, who's the customer, who's the supplier, where is the use of the goods. If the use of the goods is in a different nation, you need to look at thinking, does the service that's being provided, does that fit under the use and enjoyment rules, or does it fit under a different special rule? If it doesn't, then you look at the general rules either for B2B or B2C. So what I'm trying to do there is try and get you thinking about maybe how do some of these link to or relate to your business or your service, and just help try and understand, is it B2B, is it B2C? Have a look and see whether a special rule applies to you. If not, then how does the general rule affect me and my business or my service? So as you can see, there is a fair bit that you need to consider when you're looking at either B2B or B2C services. You need to, like I said, check and follow the special rules, and if not, and if they don't apply, then look at the general rule in the circumstances. There is plenty of advice and support available if you need help calculating the VAT obligations for your specific business, as well as support through the North East LEP or Tees Valley Business. You can access support from your accountant or an international VAT consultant. I know just if you go online, there's a lot of international VAT consultants available, and there's actually a fair bit of information which you can get for free as well. So what we're doing now is just looking at Business Bob, for example, and what he needs to find the right VAT charge for his goods. So we're talking about here the hire of the luxury ski boots and how Business Bob can identify the right VAT rate to charge. So if VAT is due in the EU, if you've worked that out, then how do you work out the right VAT rate? Well, what he needs to do is he needs to find the information, and to do that he's going on the Europa website with the link on screen. So first he goes to the europa.eu, then through to Your Europe, and then the VAT rates webpage to find the current tax rates that apply, in this case, in France. So he scrolls down to VAT rates applied in EU countries and clicks on the drop-down box where he scrolls down the list of countries to find France. And then you'll find the standard VAT rate applicable in column 3. And I think you can see that here and how that works on this page. So on the left is the landing page for the Your Europe link. Looking down the page, again, you can see the drop-down box where you'd be able to find the applicable country for you. And on the right is the list of the VAT rates by country in the EU. And like you see, you can see the standard rate, whether there is a reduced rate. In some countries, there's a super reduced rate as well, but you can see what rate will apply to you and your service. So once Bob has identified where he needs to pay VAT and what VAT rate he needs to apply, he may need to consider how to make that payment. Now, if Bob is providing digital services to multiple EU countries, he can do this, or may want to look at the facility called the Mini One-Stop Shop. What the Mini One-Stop Shop does is it reduces the administrative burden on digital services to consumers in the EU. And without this system, a business would have to register for VAT in each EU countries that they are selling into. But by using MOS, they can pay their VAT liability for all the EU countries via a single quarterly return made to just one member state. So now, with the UK being a third country, a UK business would have to use and apply for non-union MOS scheme, which can be accessed in any EU country. As an English-speaking country, Ireland, you may feel, would be a good option for you. If you're new to this, then you'll need to register by the 10th day of the month after your first sale to an EU consumer. If you've made EU sales in the last month or expect to in the coming months and you haven't yet registered, you'll be wise maybe to do so as soon as possible. As I know with COVID lockdowns, there have been some delays on the application process, and you shouldn't leave it until the last minute to apply. So like I said, if you're providing digital services to consumer in the EU, MOS may be something that you want to look at, just so you avoid the requirement of having to register for VAT in each member state where you sell our digital service. It is a good option that's available for you, and you can find out some information there on that link on screen. Again, if we link that to Business Bob, and what he needs to do is using the link, going down to your company and then select the one that best describes your business, scroll to the registration and select the country you want to register in from the drop down box marked choose country. And when here we're going to say Bob chooses Ireland, he receives the contact details for the VAT office in Dublin. It may be that if you have an international VAT consultant, they're able to provide you with this same information. But if we look at the online screens there that would be of use for Business Bob, you can see what he's gone through there to get the relevant details for him to sign up for the non-union scheme MOS. and that is who he would need to contact. Now, what if you can't rely on MOS? Because sometimes when selling B2C, the service you provide doesn't fall into the criteria of MOS. And in those cases, you'd need to register for VAT in each member state where you sell or provide that service. And depending on the member states, you may need physical representation in order to satisfy your VAT obligations. Becoming VAT registered and satisfying your VAT obligations in various countries obviously will require comprehensive record keeping, organisation, and money, especially if you need that physical representation. So what support is available for businesses who sell services to consumers but cannot rely on the mini one-stop shop? Well, from the 1st of July this year, you should be able to register for what the EU are calling the one-stop shop, or the OSS. And what this is essentially an extension of the EU VAT programme, which will help when selling to consumers. The one-stop shop will cover all B2C suppliers of services taking place in the EU made by non-EU online sellers, such as UK-based suppliers. So really, it extends what is covered by MOS and goes beyond that. So it should cover you all and cover the necessary services that you provide to consumers. An example of the type of services or supply services to customers that would be reported under the non-union scheme of the one-stop shop are things like accommodation services carried out by a non-established tax person, admission to cultural or artistic or sporting, scientific, educational or entertainment events, transport services, services of valuation and work on movable tangible property, ancillary transport activities such as loading and unloading, services connected to immovable property, hiring of means of transport, or supply of restaurant and catering services. So as you can see, it goes far beyond the mini one-stop shop, and hopefully will cover the services that you provide to consumers and give you an alternative of how to pay your VAT. So what you need to do to use the one-stop shop, well, you'd need to apply the VAT rate of the member state where the goods are dispatched to or where the services are supplied. You need to collect the VAT from the buyer on the intra-EU distance sales of goods or on the services of the supply of the services. You'd submit an electronic quarterly VAT return via the OSS portal of the member state where you registered for the OSS. You'd make a quarterly payment of VAT of the VAT declared in the VAT return to the member state where you registered for OSS, and you'd keep your records. It recommends, or it says, for a period of 10 years. So, like I said, this comes in from the 1st of July, but it's certainly something for people to keep an eye out. If currently the requirements for you and the type of digital service which you provide, that you need to register for VAT in each member state where you provide that service, we'll certainly have a look, see if the one-stop shop is available for you, and it's certainly something which should be able to take advantage of and certainly ease the burden and the onus on you. So I think with that, we've had a look at digital service, we've had a look at in-person services and VAT obligations, and with the one-stop shop, how they're going to change, hopefully in the near future. Now is probably a good time just to open up to questions from the second half of the webinar. So just a quick note really, before I finish. I think last week or maybe 2 weeks ago now, that the government announced that the new Brexit support fund had opened for applications. And what this is the grant allows businesses up to £2,000 to help SMEs access training and support on some of the things there. Most really any specific importing, exporting, or service related aspect. So that can include VAT, or if you need some more guidance and support on understanding customs special procedures, or the new one-stop shop, or your VAT implications, then certainly I'd highlight this and say this is something you can take advantage of just to get that extra support. The link there gives you some help on how to apply for the grant. And I'm sure if you speak to your LEPs as well, what we'll be able to do is provide you with just some guidance maybe on the types of businesses, or where you can look to try and receive or obtain the training or the support, the consultancy, which is best and specific to your needs. So that's something you might want to take advantage of. So really there, all there is just a list of everything we've covered. I appreciate we've flown through an awful lot in 2 hours there. And there are some things which may need to look at deeper, but certainly hopefully with what we provided, with the links and with the additional support, hopefully you can get those answers you need, and make sure that everything's set up and prepared properly for your business and your service. Because like I said, it comes back down to preparing properly, understanding what your service is, what your business does, so what requirements and responsibilities there are on your business, and putting the necessary steps in place as soon as possible. So with that, I think all that's left for me to do is say thank you very much for attending, and I'll pass back over to Tracy, who's just got a quick note.
Hi, thanks a lot, Ben. I hope you all found that really useful. As Ben mentioned, we will make all the information available for you with a practical guide, including a transcript of all the Q&As. We also will be making available a recording of today's webinar, which will be on both the North East and the Tees Valley Business Growth websites. I'd like to thank the North East Growth Hub and Tees Valley Business for making this webinar possible, and for Leslie and Parvia joining us today. They have asked me to highlight that they will be contacting you to ask for your feedback following the webinar. They've promised it's literally just a couple of questions. It'll be really quick, so we'd be really grateful if you'd take a few minutes to complete that. I also just wanted to highlight for anybody who missed the webinar on importing goods from the EU that we delivered the other day, we are rerunning that live this afternoon at 2 o'clock. So please feel free to join us on that one too, if that's of interest to you, or if you know anybody who might benefit from it. That'll be from 2 till 4 this afternoon. So finally, as Ben mentioned, this webinar was just an overview to help you understand what to look out for, and hopefully avoid the potential pitfalls that could go wrong. If you have any additional questions, or even if you just want a general chat about your own specific business or situation, you can access one-to-one support from both of the growth hubs. If you're based in the northeast of the region, you should contact the number on the screen there, the telephone number, or you can access them directly via the website and get in touch with one of their connectors. If you're based in the Tees Valley, you can see the 24-hour telephone helpline number there, or you can contact us directly by email on the email that's shown on the screen now. All that's left for me to say is thank you very much for attending. We hope you've enjoyed it, and we hope to see some of you this afternoon. But in the meantime, enjoy the rest of your day and stay safe. Thank you very much.